well as we will be distributing the slides. So everybody will have a chance to really absorb this content. So with that, I want to turn it over to Chris Spittler from Vanderpool, Frostick, and Nishishian.
Shanian. There you go.
I knew I'd mess that up. And for those who don't know Chris, and I'd be surprised if you don't, if you're in the HR profession in the DC metro market, Chris, spends a lot of time talking to and working with HR professionals and businesses in the DC metro market. Maybe beyond that, Chris, I don't know. But a couple key things I would like to share about Chris is that she's a founder of Prince William SHRM, which has thrived as a chapter. Many people on this call and many people probably are familiar with the Prince William SHRM Law Summit, which has been a huge success, highly attended and really good event. That was just in October. Obviously, they had to pivot to a virtual event, but from what I understand, it was still a very, very good event. And more importantly, the services that Chris provides to her clients in all legal aspects regarding employment law. I don't know, I'm sure it goes beyond that, Chris, and I'll certainly give you a chance to talk about that. But today we're going to have a really important topic on business in the time of Corona. What we've seen is from our clients is this is a topic that keeps on being such an important subject. And Chris and I were talking briefly before starting the presentation that everybody's so busy in their businesses, working on their businesses, dealing with COVID, from running their business and keeping their businesses running, that sometimes some of the compliance issues and the legal aspects fall through the cracks, which we all know we can't afford to have that happen. So with that, I'm going to turn it over to Chris and take it from here, Chris.
Thank you, Dario. First, I want to thank you and Hill Group Mid-Atlantic for having me and an opportunity to talk with all of the businesses who are on the call and say, really an opportunity to help you do your business and help you be in compliance as best we can. I mean, that's one of the things that our firm works really hard to do, is try to help our clients and help the business community thrive. And despite the challenges that there are now with COVID-19 and the pandemic, and I would say probably a little bit further with some of the divisiveness that plays out in the workforce, there's an awful lot that we're trying to do to help you survive and thrive as a business in this environment. So one of the things that I want to say a little bit about my firm to start out with, it's a full service business firm. So we focus on businesses from the creation of a entity, LLC, or a corporation, partnership, joint venture, all the way to the end. If you are terminating or dissolving your business, perhaps you're selling your business or you're purchasing a business. So sort of the whole life cycle of a business. And then everything in between, which can include, having to negotiate leases, purchase real estate, do zoning, prepare contracts, do loans and have to borrow money, have security on your property, litigation. I mean, it's really a full service. In addition, we recently added a criminal law practice where we brought on an attorney who is a assistant Commonwealth attorney he'd been for 10 years and now is with our firm defending on criminal cases. And he and I do a lot of investigation. So if it's a criminal investigation, a white collar criminal investigation, we do those, as well as probably what you guys might be more familiar with is also the employment, such as discrimination or fraud or trade secrets or intellectual property type issues. As part of our representation of our clients, we do have an intellectual property practice. We do trade secrets. We have an agritourism practice where we are representing a lot of businesses that are the wineries, breweries, farms that host events. So we are excited about that and frequently do wine tasting with our clients' wonderful wines.
Not a bad part of your business, Chris. One thing that I don't know if I understood clearly, with employment law, do you always represent the employer, or are there times that you can represent an employee too? I know that can be very different from firm.
Yeah, we do both, but I would say primarily we represent the employer. So we focus on the business since our practice is a business oriented. That is generally what we end up doing, but we will also represent employees. And typically where that comes up, if it's a non-compete or a non-solicit provision, and maybe it's an executive, because it tends to be executives who end up with the non-compete or non-solicit contracts in their employment agreements. We will represent the employee on that or the employer in that. And then we also do a lot of drafting of executive employment agreements or reviewing those for people, which could be on the employee side as well as the employer side. And then last, I would say probably the other area tends to be when you have severance agreements. We will often represent, and work with employees dealing with whether they should sign an employment agreement or whether they have a severance agreement, and if you've got non-compete provisions, or is this severance agreement the right thing for the employee to do under the circumstances. So hopefully that kind of helps clarify some of that.
It does. Thank you.
A great question, though. So one of the things I wanted to really focus on today is some of the issues that are coming up for a lot of our clients dealing with coronavirus, and some emergency temporary standard that Virginia enacted, as well as some of the litigation concerns that are out there right now that are starting to work their way through courts. And so I want to kind of give you the heads up so that as you're going about your business, you can really think through, is this something we have to worry about? Where are we? What kind of decisions should we make so that we try to minimize that risk? So one of the things that I have to do for my partners as well as my malpractice insurance is to say, when we give these presentations, it's not meant as legal advice. So it's just meant as general information. However, should you need to have a specific legal advice or tax advice, you should seek, certainly, either your attorney or hire an attorney. Of course, we're happy to help you if we can, if we don't already represent you. So. I think Dario's already kind of gone through a little bit about my bio. I don't want to spend too much since you guys can get a copy of the slides. I'm going to kind of go past that and really kind of get to the actual substance here. So one of the things we're going to talk about today is Virginia's new emergency temporary standard. And I'm going to talk a little more about it in detail, but it really is a sea change for Virginia that's kind of been sweeping along with the new General Assembly and some of the legislative changes that happened that went into effect primarily on July 1 of this year. They also had a new emergency temporary standard to deal with COVID-19 that was enacted. So we're going to go through the details of that and really kind of focus on what your business should be doing. If you've already addressed it, then, kind of doing a double check. And if you haven't, then we'll kind of go through what you should be doing. As I said before, we're also going to talk about some of the litigation concerns, some of the areas that intersect either with some of the laws that you already know, or where now there's some new things that are kind of coming up that businesses that hadn't really thought about it before now may have to start thinking about it a little differently. And then kind of follow up with some recommendations of things that we think would be helpful for your business. So starting with the Virginia's COVID-19 emergency temporary standard, Virginia was the first state in the entire country to enact its own workplace standard. And really what it's intended to do was to say, okay, we understand that you've got guidance from the CDC. We understand that there is guidance from OSHA. There's a lot of federal things out there, but we're going to enact something that applies to Virginia employers. And so really what it was trying to say is that we're going to regulate businesses and talk about what's the standard to control, prevent, and mitigate COVID-19 and the spread of it in a workplace. So many employers may not know about, you think about OSHA, and that's a federal program. And what OSHA does is it sets out the health standards for a workplace safety. And so if you're in the construction industry, railroad industry, manufacturing industry, a lot of those will be very familiar with what the OSHA requirements are in health and safety in the workplace. Some of your other businesses may not have had the occasion in the past to have to worry about it as much. Doesn't mean it didn't apply, but it wasn't something that became a big issue for you. What that is that, okay, OSHA is the federal law, and then because it's a federal system, each state participates, but each state is allowed to create their own program, and Virginia is such a state. So it created its own workplace safety, and it's under the Virginia Occupational Safety and Health Program, or VOSH. And VOSH is under the Department of Labor and Industry in Virginia. So what they did is they enacted an emergency temporary standard, which is an extensive list of requirements that employers within the VOSH jurisdiction have to do. So the question is, are you an employer within the VOSH jurisdiction in Virginia? And for most employers, the answer is going to be yes, unless you fall under a separate federal law, such as mine and safety, railroad, if you're a trucking company. There are a number of federal laws that specifically apply to you. So if you don't fall under one of those, then the general belief here in general law is that you would be covered by this emergency temporary standard enacted by VOSH. So because it's an emergency temporary standard, it was enacted in July 27th, and it wasn't given a whole lot of information or publicity ahead of time before it was going to become effective. So I think it took a lot of employers off guard. Frankly, I think there's still a lot of employers who are not even aware of this law and what they're required to do. So the idea was that it was going to go into effect. It was going to be effective for about 6 months. And then when the governor's state of emergency expired, or 6 months, whichever occurred first, it would sunset, it would end. Then, because of sort of the idea of whether this should become a permanent standard, that was something that the Virginia Health and Safety Codes Board decided to reconsider and make this permanent. So there was a hearing, and there was an awful lot of pushback by a number of businesses, and particularly the Manufacturing Association and businesses who are manufacturers. But in addition to a lot of other businesses who said, wait a minute, we're already dealing with a lot of challenges right now. We're just trying to keep our head above water. We're trying to deal with, all of this, keep our employees going, keep safety. So we really don't want to have this additional layer of regulation on us. And sometimes it creates some ambiguity, particularly as it may not always correspond exactly with what the CDC's guidance is, or sometimes the CDC's guidance actually changes or is updated. And because you've got this standard that went into place in July, it may not always correspond to what the CDC's new guidance is. So it creates a little bit of a challenge, but I think, overall, I think we can kind of work through that and help you understand what you have to do in order to comply with this standard. As I said, it's scheduled to sunset on July 27th of 2021. And as I said, they're looking at potentially making this a permanent standard. There is a hearing scheduled now, looks like, I think, at the beginning of December, where the Virginia Safety and Health Codes Board is going to consider, again, whether to make it permanent. And I've given you some a website down here where you might be able to kind of follow that and see. I don't know whether they're going to be accepting any more public comment on that, because that was one of the things that they were particularly doing at the last hearing. But obviously, if this becomes a permanent standard, then you definitely will want to make sure that you are in full compliance. And then as the standard may be changed, you want to make sure you are following that. All right, so let's talk about what that emergency temporary standard, and I'm just going to say ETS for short, or the emergency temporary standard, but you'll understand what I'm talking about. What it requires is that employers go through and do an assessment of their workforce, which means each position that they have. you do an assessment as to the exposure, risk exposure they have to potentially getting COVID-19 and spreading it in the workforce. And so one of the things that you have to do is this assessment, hazard assessment. And you have to create a form that shows you have gone through. I recommend that you list each position, and then you determine what type of things that an employee's position would do. To give you an example, let's say you are an office worker and your office workers are all desk or at least 6 feet apart. Then, you know, you're saying, okay, maybe the exposure is not very great and they'll fall into one of the lower categories. But what if you've got employees who are office workers, but those workers are actually closer than 6 feet? Then maybe you need to look at some different strategies that you want to do to try to limit the exposure and the potential spread. So as you're going through and looking at this and you're creating your hazard assessment sheet or form, is you're looking to see whether employees fall into one of 4 categories: very high, high, medium, and lower. And I kind of laugh because it's not low, it's just lower. And that follows sort of what the OSHA requirements are in terms of risk assessment. So based on that exposure risk level, then you've created this hazard assessment. And one of the things that the employers have to do is have an officer of the company have this written assessment, and they're supposed to be working with their employees. They're not supposed to just say, okay, here the officer went through and said, yes, 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 no, nope, not much of a risk, and, you know, put it on a sheet and that's it. The guidance and the regulations specifically ask the employers and require the employers to work with their employees as they create this assessment of what their employees' risk hazards are. So as you create that, you work with your employees, you write down this form, and at the end, an officer of the company signs this form, and it's supposed to be kept available for anytime somebody from the Department of Labor and Industry in Virginia comes to look, if they do, or if an employee asks to look at it. You are also required to let them see that as well. So where does their idea of they have the ability to require this for employers, and how does that, you know, come about? And again, it was coming about because of the governor's executive orders declaring emergency, which, you know, we've had several different ones. It's changed. We've gone back to first, you know, we had it everybody staying home, then we're slowly getting back to work in different phases, and where we are now. Now it may change because of course there's some issues of potentially, you know, a second wave, as they're saying right now. Maybe for some it's a third wave, but whatever the situation is that you still have to pay attention to the governor's executive orders. And ultimately the governor's executive orders is something that you're going to have to ensure that you comply with. One of the things that the emergency temporary standard does is it says, you know, if you comply with the emergency, the executive orders, as well as any CDC guidance, then they're going to say that you're in compliance with this. You know, there haven't been any litigation cases yet that I'm aware of that have actually determined which of those are going to govern. But as you're going through it, you know, if you're more risk adverse, you want to make sure you're kind of looking at all of those regulations and determining that you're checking the box on all of those. If you are less risk adverse and you're saying, listen, I'm complying with the Virginia standard under this ETS, that's enough. Or if I'm just going to look at the CDC and I'm, you know, so long as I'm just doing the procedures that the ETS requires, then I feel like I'm good. So there's a wide variety of those, and we can kind of talk about that a little more as we go through. All right, so what are those 4 different areas? And as you're determining whether you're in the high or the very high, the medium, or the lower risk. Some of the examples of if you fall in the high category are, you know, people who are actually working with people who are COVID infected. So you've got people who are the hospital workers who are working directly with the COVID patients, some of those. And there are some very specific requirements that the ETS provides for ensuring you're providing personal protective equipment, the policies and procedures you have in place to ensure the safety of the employees. So then if you're in that very high category, you are required to do an infectious disease preparedness and response plan. And you're also required to do training of your employees. And it's based on your being at the very high. So you may have some employees, let's say you're a hospital, who may be at the very high, but you have some employees in a different part of the hospital who have absolutely no connection or interaction with somebody with the virus. And so maybe they're at the medium or lower range. So what they're really trying to say is adapt your plan for what your actual circumstances are. If you are an employer with some very high employee risk category, then ensure that you are looking at that standard and following exactly what's required. I would say for the most part that a lot of employers who are in that very high category already know that and are already working very hard to ensure that they're in compliance with that. So then you can go down to the high category. And these are people who are like your emergency response people, your paramedics, things along those lines, who may ultimately have some connection. And again, the idea is because they're high, you have to follow what the requirements under that standard are for having the protective equipment, having the policies that are and information available for people to ensure that they're protecting themselves.
Hey,
And
Chris,
then
can
yes,
I
sir.
interrupt? We had a question
Absolutely.
in regarding, is there a specific form that the VOSH wants the officer to sign? I think this is going back a slide or two.
Yeah, actually, that's a great question. If you go to Virginia's Department of Labor and Industries website, they actually have quite a few forms and things that are really helpful for employers to do, including a sample form of that hazard assessment. So you could just print out that hazard assessment form. Of course, you have to make it applicable to you. And, you know, going through some things that we've helped employers do is look at, so if you've got very high categories, they kind of look at employees and they say, okay, we are a HVAC company. So we send our employees out to people's homes. And if they're at their people's homes, then they have some potential exposure. So they look at sort of the people who are going into people's homes and they kind of list those as one category of employees. They have office workers, that would be a different category. And then maybe with different office workers, you may have different risks depending on, you know, each subcategory there. And as you fill that form out, you're supposed to be working with your employees again, developing and saying, yeah, do you agree that, you know, this is where you would place the employees in this category as either very high, medium, or lower. Fill out that form and then you can sign it and then you keep it so that it's available. So yes, there is a form available that should make it easier.
Thank you, Chris.
Great question. So as you get through that, what I tried to do on this slide is kind of summarize for you. If you fall or have any employees who are in the very high, or medium category, if you are a retailer, chances are you are definitely in the medium category, which means you have employees who are having exposure to the public. If you're a grocery store, Starbucks, you know, any of those, you're going to have some employees who fall in that medium category. So with that, in these three levels, you are required to have an infectious disease preparedness plan, and you are required to do training. One of the things that is available on DOLE's website is a PowerPoint presentation that talks about, I think, if you gave that training and followed what that presentation is, you know, you can just download it, you can use it, you can, you know, mend it to make it applicable more to your particular business. I think that would go a long way to satisfying the training that you need to do. I will say that the law and the regulations actually were very specific about a time frame within which you're supposed to do it. All categories that are in the very high, high, or medium were supposed to have enacted their response plan by September 25th. And then they were supposed to have completed their training by August 26th. I can tell you that I have clients that are coming to me now and maybe got through the first wave of COVID and didn't have any employees with COVID, didn't have any concerns, and were completely unaware of this emergency temporary standard. And now they have been calling and saying, hey, we had our first employee with COVID. What do we need to do? And we start walking through that. And one of the things I found is that many of them were not aware at all that they had this emergency temporary standard requirements on them. So clearly they haven't complied with the time, deadlines that were put in place. But obviously the sooner you do that and get that in place, then, the better it is to say that soon as you became aware of it, you acted quickly and got it in place. If you are, and I'm going to deviate a little bit away from the emergency temporary standard, but just kind of as a thinking through where you are. If you have an employee who has COVID now or tells you they've tested positive for COVID, you do need to be aware of the Family First Coronavirus Response Act. I'll call that FCRA for short. And that is a federal law that was enacted under the CARES Act that requires employers, unless you have 500 or more employees, to provide certain paid sick leave and certain paid family medical leave. So if you, for the first time, are now dealing with an employee with COVID, you have to be aware that you may be required to, unless you're a larger employee, 500 or more, you are required to provide up to 80 hours of sick leave. And if it's part-time person, then it's based on a proportional pro rata rate to what their hours they work in their position. So you would need to be giving notice. The good news under FCRA is that the employers can have a tax credit for the hours that they paid for employees to be off for that. But you want to have paperwork that you create and that you have in files, because if you're going to be using it as a tax credit, your accountants are going to want to make sure that you have the paperwork that supports that. So if there are any questions about FCRA, I'll be happy to answer those. It's just a whole lot to try to cram in 1 hour. So I'm just kind of issue spotting for you here is if you're one of those businesses that you've managed to make it through up until now, and now you're ending up with an employee with COVID, that you should be looking both at the FCRA law as well as the emergency temporary standard and the CDC guidance. All right, so what if you are a business that is fortunate enough not to have anybody in the very high or medium range? So you really consider that you are, let's say, an office environment where your employees are not 6 feet, or closer together working, or you're doing shifts so that you have they don't fall within the 6 feet of each other while they're working. Then you have what you fall in that lower category. And it's not that you don't have any requirements, but you don't really have to do the infectious disease and response plan, nor do you really have to do the training. Now, I would say most of my employers who fall in the lower category are opting not to do the response plan. Many of them are saying, hey, we've already had a number of things in place. We already have the signs up. We already have, one-way hallways or stairwells going up or down. Lots of different ways that they're trying to protect their employees. So one of the things I strongly encourage employers to do is take pictures of that. If you have a lawsuit that, is filed, let's say a year from now, and you no longer have, all of these protections in place, and you're saying, yes, we had our signs up, we had our, hand sanitizer out, we had our signs up for hand washing and staying distance and various other things. Take pictures of those and create a file so that you can show all the efforts that you took to protect your employees under these circumstances. So what a employer that falls in this lower category, what they want you to do is at least inform your employees about the characteristics and methods of the transmission of COVID, the symptoms of COVID and the ability of pre-symptomatic and asymptomatic people to be able to transmit the virus. They also want you to talk about what kind of safe and healthy work practices and control measures you have in place. Again, I think for many of my employers, even if they haven't heard of the ETS, have a lot of these in place. So it's just a matter of, again, trying to show here are all of the things that we're doing. I'll talk about the anti-discrimination provision in a minute, but just be aware that it exists. So when we're talking about the anti-discrimination, I think many employers who are dealing with any type of discrimination claims under Title VII, if you have 15 or more employees, now you have different coverages under the completely revised Virginia Human Rights Act. So I would say for most employers in Virginia, you're going to have to worry about the anti-discrimination. And they've built that concept into this emergency temporary standard. So if you have an employee who says, I want to, I don't think it's safe here and I want to bring up this concern about my safety, then you are prohibited from discharging or discriminating against that person because they brought up their rights under the ETS. It also means that you can't discriminate or retaliate or discharge somebody who wants to wear certain protective gear in the workplace. And I'm going to say my experience has been in Northern Virginia that there is a lot more people who are wearing masks based on my discussions with the employers, our clients, and that in some other parts of the state, there may not be as much feeling of a need to wear the mask. The law is, and what the governor has asked people to do is there. But right now in the country, as we can see with our election, there's a lot of different views. You have some people who believe that the COVID's not as bad and they don't want to wear a mask. And then you have others who find it's morally reprehensible that you interact with anybody, everybody should stay home. So recognizing that this is where we are now as a society, and certainly in Virginia and probably in the entire country, is you have that wide variety of views, and that those views are brought into the workplace that can create a challenge. So let's suppose there's, and I think this is sort of what we found over time, is that there's a group think that kind of happens at a workplace oftentimes, particularly if they're smaller. And if there's a view that, we shouldn't be wearing masks, there's almost a reluctance of some employees to come to work and wear a mask or wear something that's more protective, or to express concern about it. And so what this regulation says is you can't discriminate. So you've got to be careful that you as an employer, not just you as management, but that you're creating a situation where your employees are not making it discriminatory or difficult for somebody to wear that mask in the workplace. I will tell you some examples of some situations that we've had from some clients. I've had a client that had an employee who there was some doubt whether she really had exposure to COVID. She had gone to the doctor, had a negative COVID test, and then still felt like she should be staying home. And then in all of her communications to her employer, were constantly, the ray line was my rights under ETS, or my rights under CDC, or my rights, are being violated. So certainly, you have employees out there that are very much aware of these concerns and wanting to make sure that, their rights, they have a right to take FIC relief, they have a right to be protected and not have to work if they think it's a unsafe work environment. So again, I'll point you to sort of that last bullet there, is it specifically says in the emergency temporary standard that nothing shall limit an employee from refusing to do work or enter a location they feel is unsafe. I have not had too many scenarios where that's happened. But I will say that if you are representing a school district now with the teachers, or if you're a private school, that you're going to have some of that, and there's some potential issues of if an employee says, I don't feel safe coming to work. how do you make the employee feel safe? Some of these things you could potentially remedy. It's not an all or nothing. You may have a particularly challenging employee that no matter what you say won't make them satisfied. But I found as a practical experience that the more you talk to the employee and you say, hey, here's the CDC guidance, here's all the things that we're doing to try and make it safe. We really value our employees and their safety. And obviously we want to protect you and everyone else. Here are all the things we're doing, that a lot of these things have been able to be resolved in a mutually satisfactory way. It's not to say that every situation will be like that. Some, as I said, if you're somebody who says, you know, it's morally reprehensible, or you have an employee who feels it's morally reprehensible to come to work because, this is a pandemic and no one should be having any exposure, you're going to have a harder time with that employee than if you have someone who just says, hey, I don't feel safe, but tell me all that you're doing. That will help me feel better. All right, so let's briefly talk about sort of, there has been a lawsuit that has been filed challenging the emergency temporary standard. And this was by the Manufacturers Association of Virginia. And several employers have filed suit to enjoin the enforcement of the Virginia emergency temporary standard. And this is sort of the idea that they're not only challenging in some of these lawsuits the ETS, they're also challenging the governor's ability to close businesses or restrict businesses from operating. And so some of the grounds that you will see, and I'm sure you'll be hearing this in the news as it goes through, and as unfortunately it appears we're continuing to deal with COVID, is some of the arguments that are challenging these is, one is the failure to follow procedures prescribed by the Virginia Administrative Act. That's where you have to do certain public notice to people, to the citizens of Virginia, so that they understand what the law is, have an opportunity to weigh in before it goes into effect. So there's some arguments potentially that there was a failure to follow that. Arguments that it is ultra vires, which means that they are actions beyond the authority given to the governor to enact these restrictions on the rights of association or assembly, particularly in the faith-based communities, whether that is a violation of their rights, undue interference by the governor and an independent agency, failure to establish that an emergency standard was actually necessary to address a grave danger, particularly with the low hazard employers. So if you fall in that lower category, the argument is, hey, we shouldn't have any regulations because, the risk is not warranting the regulations. Arguments that the ETS is unconstitutionally vague language in identifying individuals suspected of COVID-19. So an example of that is there is a provision in the ETS that talks about employers should be providing flexible leave. Flexible leave is not defined, and there is no requirement anywhere that employers are required to do that. So you have a regulation saying that you should do that, no definition of what that means, no support for why they can require that. I think it's sort of following what I'll say the CDC is encouraging employers to do, and what I'll say, quite frankly, I find most employers actually doing, not because it's required, but because they're working to, keep their business going, address their employees' concerns, and still, keep the business functioning and profitable, or at least surviving. Again, like I said, the leave policy perhaps exceeds their authority, and the infeasibility of employers' ability to follow the standards. So that's some of the challenges that you're seeing out there, and have yet to have any particular ruling by a court. So until that happens, I think employers should be complying with the ETS. All right, so let's talk about some other types of litigation that's out there. So you have the ETS that's out there. We know we also have FCRA, the Family First Coronavirus Response Act, that requires employers to provide certain paid leave. And so now you have businesses are trying to survive, all of the chaos right now of just continue to keep their business going, dealing with employees who may or may not be sick, who are worried. I will say that I have a lot of clients that are challenged by employees who have to stay home or have flexibility in their work schedule because the schools are closed. And FICRA does have a provision that you have to pay family medical leave for employers or for employees whose childcare or schools are not open. And I could spend a whole hour on talking just about compliance with those FICRA leaves, but at least be aware that it's out there. And so take caution when you have somebody who's saying, hey, I'm sick, or I can't come in because I don't have, any childcare, or I can't come in because I'm having to teach my kids from remotely. So a lot of things that you're having to deal with as an employer, and I can tell you that you're not alone, because I'm certainly finding a lot of my clients challenged with that. So for the employment discrimination, let's talk a little bit about some of the types of those concerns that I think you have. Is the EEOC has put out some additional guidance, and the challenge that I think that's happened for a lot of employers is all of these different things are out there, and when do they get updated, and how do you know? And what changed from the last time that a regulation came out or guidance came out? And sometimes it's really challenging to kind of keep track of that. But there is guidance in case you're interested or you have a challenge. You can look, the EEOC has put out some guidance about making sure you're complying with the Americans with Disabilities Act. And so right now it's not clear whether COVID would rise to the level of having a disability. Again, the concept of a disability is it shouldn't be a short-term issue that would fall under a disability, but because of the 2008 amendments to the ADA, I'm not sure whether it would or it wouldn't. So I would err on the side of trying to work with employees and involve them in determining whether you have to provide any reasonable accommodations. Again, for those who may not be aware, the ADA applies to you if that's a federal law that applies to employers if you have 15 or more employees. Virginia Human Rights Act would apply to you if you are a smaller business. So I think for most employers, you're still going to have to worry about that. I've already talked about the work from home and leave claims and the improper denial of leave. There are some employers out there who have contacted me after they've denied leave to employees who claim they're either sick or believe they have symptoms and going to get tested for COVID, or because they are caring for somebody who is sick and need to stay home or use some of that leave for that, or again, because of the childcare or school situation. So again, we want to make sure we do that. We want to have some forms that you have created that you can keep in your file because of the tax reasons, and because you want to, if something happens years down the road, you want to make sure that you can remember. I can't tell you how many cases in litigation that we've had where the business knew what they were doing at the time, they acted appropriately, but the employee who was handling that has long since left the company. They don't have any documentation, and it's just a challenge to try to prove their case, which is unfortunate. So I would say, again, think of it as just covering yourself and creating a paper trail so that you have that protection. Again, the retaliation, we've already talked about that, is that if somebody brings up and believes that they're sick, or believes that they're going to use their FICRA rights, or going to complain about the working and safety in the workplace, is that you're not supposed to discriminate or retaliate against them. The unsafe working condition, I think you're seeing that it kind of peaked a little bit more at the beginning of the summer. Then it seemed to have subsided, at least in terms of my clients that I was dealing with on a regular basis in August, but that seems to be coming back up again because of the second wave. And now sort of the employers who may not have had to go through this the first time, I'm finding some of the employers who now are having to deal with it for the first time. So just be aware of that and make sure that if you have questions, you seek counsel. The other area that I see challenges is the wage and hour. When you have employees working remotely, you have to be really careful about ensuring that you're paying them for the time that they're working. I've had employers who have not really been keeping track of non-exempt employees time working from home. And then after the fact, they come in and say, hey, you know, I've been so busy, I've been really working, and I've been working many hours over my, you know, over 40 in a work week, and I want the overtime for that. So it's a little bit more tricky. And again, wage and hour, that's under the Fair Labor Standards Act. That applies to most employers. The general definition is if you have 500,000 in revenue and engage in interstate commerce, the FLSA would apply to you. There are some occasions where the FLSA will apply to individuals, even if the employer is not covered. So just kind of a heads up for that. All right, things that you might want to consider as you're kind of moving forward is you want to make sure that your inquiries or medical examinations do not run afoul of the ADA. As I said, one of the things that I think happens with some of the employers is if somebody comes in and says that they have an employee, or the employee themselves say, I have COVID, or I tested positive, or I think I have, is the word gets around, and that is a violation of the ADA and probably a violation of the privacy rights of the individual. So if you have an employee who comes in and says that they have COVID or tested positive or think they have, you have to protect that information as confidential. So you'll get a lot of pressure from everyone around who says, oh my gosh, who is it? I want to know, because I want to know if I've been exposed and I got to protect the people at my house. You can't do it. They may be able to deduce by their own who it is based on who's not in the office, if you're a smaller business, or who's not in a position or whatever, but you can't say it. You can say, you know, somebody in a certain department, you know, somebody who's a, you know, legal assistant, somebody who, I'm just giving you kind of ways of giving categories so that you're not identifying who that is. So just make sure that you are keeping that confidential. When you are terminating anybody or demoting anybody from COVID-19, and that can happen because you have people who will say, I'm not coming back to work. I don't feel it's safe. I have, you know, elderly people that I'm living with at home and I don't want to come back. And you're feeling as well, there's no reason that they can't work. We provided them an opportunity to work remotely, or we create shifts at the office so that they're not being within 6 feet of others. So, you may have that tough decision of whether you can still keep them, or because they're critical, and if they're not performing the functions, you can't continue. You really do have to have somebody in the position doing the job. Again, when we're talking about the ADA, is whether you should engage in the interactive process, and talking about whether you actually have to provide an accommodation. Again, under the ADA, you should provide reasonable accommodations unless it creates an undue hardship for you. So the other question I get frequently is whether an employee who has COVID-19 presents a direct threat to their own health. And you got to be careful is that you can't, because you suspect they have it, you cannot say you can't come in. You can tell them if you have any symptoms, then we request that you stay home. In fact, we tell you to stay home, but you can't terminate them, you know, just because they may have those symptoms. A lot of confusion out there is that if they are able to do remote working, then they may not even need to be provided FIC relief, much less any other type of accommodation, because either you have them working remotely or that is a reasonable accommodation, is you can continue to do your work from home. It still needs to get done. You're just doing it from home instead of at the office. All right, there is some pending federal legislation, a Safe to Work Act. This is intended to try and protect businesses, you know, from insubstantial lawsuits related to COVID-19. And it makes it more difficult for workers to sue if they get sick at the workplace. Unfortunately, it has not passed yet. I suspect that obviously with the elections, a lot of attention has been focused there. And then perhaps after we get through the election process, then Congress can go back and look and decide what they're going to do with some of these additional legislations that's pending out there. The nice thing is that if this passed, it would cap punitive damages, set clear and convincing evidence of burden of proof. I mean, honestly, I'm going to say that I think the issues of COVID-19 are just at the beginning and working there and starting to work their way through. There have been lawsuits where family members of someone who has died has sued their employer, arguing that they did not provide a safe workplace for the employee. They believe they caught COVID because of being at the workplace, because they died, and suing them, in various different states, arguing it's the employer who is responsible. From an evidence standpoint, how do you prove that? In one case, they're arguing that the employee was told they didn't have to wear a mask at all during the workplace unless they're, doing a certain job. The employee was hugging other people. One of the people they hugged was somebody who ended up getting COVID-19 and ultimately dying. So on the other hand, I've had clients where they had employees who ended up getting COVID, obviously not sure how they got it. It doesn't appear that it originated at work, but once they were there, they ended up spreading it. And they had an employee who sort of stayed and kept the fort down and did the work. And as a thank you to them and saying, hey, I know you've worked really hard. Why don't you go ahead and take your vacation? So the employee took their vacation, and unfortunately they went to Myrtle Beach at a time when there was a high level of COVID there. And what resulted is he came back to work, first day of work, he ended up being sick, going home. He had COVID, and now because he'd also spread it to other people or had close contact with some other people at the work. So, it's a challenge. And then how do you prove it? Because in that case, it wasn't because the employee caught it at the office or was exposed to it. If you go to the grocery store, if you go get gas, I mean, it's just going to be a big evidentiary issue. And how much is that going to, pose a burden on employers trying to defend against that? So I honestly think this is a good act that I think Congress should take up to help protect some of the employers, because it's been a real challenge trying to navigate all of this. So some action steps that I would suggest you look at is, one is certainly looking and ensuring you're complying with these federal and statewide regulations. And if there's any local in your individual jurisdiction, then you certainly want to be looking to do that. I think you also want to be looking whether you should update your employee handbook. Some employers are saying, yes, we're updating our handbook, including new policies, because now we recognize we have the ability to work remotely. Before this, we never wanted anybody to work remotely. We didn't think it was going to work. We didn't think people were going to work. We found that because of the pandemic and the necessary protections, we found it worked. So now we need to have a telework or a remote working policy. Do you need to have policies to deal with attendance and scheduling and being remote? Who gets to work remote? When do they work? Are you going to have flexible schedules that allow different people to work different hours, particularly in light of trying to comply with the work from home, teaching your kids at home now, virtually, or not having childcare? Should you have policies now dealing with your safety? Should you have a policy dealing with travel? In an example I just gave of somebody going to Myrtle Beach when there was a high level of virus being communicated through the community. Do you want to have it? Certain jurisdictions, DC, for example, has restrictions on travel. Do you enact your own travel policy? If somebody goes somewhere that may be a high risk, you want them to stay home for 14 days before they can return to work in person. If they're working remotely, do you care? Technology, are you giving people laptops or equipment that they're at home? Do you need to address how they do it? Where is your information being saved? What's the exposure? Is there any security risk to that? Do you need to update your training policies? And last but not least, considering what type of group health insurance. So there are a lot of things, I think, that businesses, on top of having to deal with all of these challenges, there's a lot that I think you can try to kind of refocus and do the best you can to protect yourself from the defense side. So I'm going to kind of end here with, what can an employment law attorney be helpful for you? And I'm going to say from our experience is that we sort of have a wide range. We have some employees or some employers and clients who really do most of their own work, and then they retain us on a regular basis and just say, hey, when I have a question, I just want to pick up the phone and ask, because I know I can get a quick answer and I can refocus on my business. And so, that's certainly fine. We do that for many of our clients. Then we have some who are sort of in the medium range, which says, hey, in our particular industry, we are a plumber, HVAC, whatever, we have some particular concerns about making sure we're in compliance. Really would like to get more services from you or more help in creating our policies or our infectious disease plan, or determining, our compliance with wage and hour or ADA or various other things. And then I would say we sort of have a last group, which I think is kind of funny to raise the white flag group, which is, oh my gosh, I'm so overwhelmed. I'm just trying to do everything else. Can't you help me? Just help me put all that stuff I need in place, and then I can focus on my business. And so we're happy to work with you in any of these range of businesses. And I'm sure there are other employment lawyers who are able to do that. So that's sort of what I think is sort of a big overview of where we are in dealing with COVID-19. So I'm open for any questions, Daria, that you have or some of our attendees have.
Sure. Well, I appreciate that, Chris. That was a very comprehensive overview, and I know condensing that into 60 minutes or 50 minutes is challenging. I certainly open it up to the group here. If any questions, feel free to unmute and fire away to Chris. As people maybe are figuring that out, Chris, one example that we've discussed over the past 6 months is making accommodations for employees that have kids at home. Mm-hmm. It seems like there's been a general attitude from employers to allow some accommodation and understanding, let's call it, but there's going to be a point where that runway ends and people just need to figure it out, so to speak. Can you give us some context on how to handle that, or is there any legal guidelines or guardrails that protect either the employer or the employee?
Well, the first thing you got to look at is the Family First Coronavirus Response Act, because the law does provide for paid medical leave for employees who are unable to work. And that is the only category under FCRA that they allow it to be on an intermittent basis. So, but it's at the discretion of the employer. What I have been finding as an overall practical experience from them is that most employers want to work with their employees because it's going to be more costly to try to bring in somebody new, try to get them trained, try to get them in place with everything else. So what I'm finding for the most part is people are trying very hard to do that and being somewhat flexible. But you're right, there comes a time where, because of their schedule and their need to be home and take care of their kids or do remote learning or teaching with their kids at home, that they're just not doing the job. And what I would say is, I think you really want to have some communications, written evidence that you have been trying to work with the employee and say, hey, tell me what your hours you're available. Let us figure out if that's something we can work with on intermittent basis or even remote. So you can let them work remotely if that's available. If not, you can say, listen, you need to be in the office. I can have you in the office 3 days a week. The other 2 you can be off. I mean, there's all kinds of different ways that you can try to really think about how you could accommodate that employee. But if at the end of the day, after you've explained, some communications, and I would take notes if you have to about your telephone calls, I would put it in writing so that you show you've communicated with the employee. And then if at the end of the day, they're just not able to do the job, then you need to tell them that, listen, I can't have you because I can't keep going and not have this job, that you're hired to do actually done. And so again, what I would say is that I want my clients to come in if we have any type of EEOC investigation, wage and hour, OSHA, VOSH, whatever, or go to court, is I want my employers coming in with the white hat. And how do I get them in the court with the white hat is, even though you'll get pressure from management or supervisors or just your own frustration of wanting to just cut it short. I want to be done. I don't want to have to think about it anymore. And they're taking advantage of us, or they're bad people, is that I really caution you to try to create that paper trail to show that you've tried to work with the employee and say, hey, we understand where you are. Here's what we're able to do. And you try. And then after, enough effort, and it's no bright line that I can tell you when is enough effort, but so that you've got some paper trail that says you were the reasonable employer, you gave enough notice to the employees so they could make their own decisions and understand that their job was at risk if they couldn't do the job. And then from there, you can say, okay, we've done all we can, and I'm sorry, but we're going to have to, separate employment.
Okay, makes really
and
good.
I'm sorry. And the other thing I would say that maybe in those circumstances is you may want to have a severance agreement and have them waive claims so that, yes, I know they're not working and you may have to, ultimately pay a new employee, but there may be some benefit from obtaining that waiver in a severance agreement in that circumstance.
Good point, just for some additional protection.
Right.
Thank you, Chris. Well, again, as we wrapping up, I wanted to offer up anybody to ask a question before we close things down. We don't have anything in the chat. I will remind everybody that we will have a recording of the presentation along with the presentation. Feel free to reach out to Chris for any legal issues that she addressed at the beginning of the webinar. And with that, I think we're going to wrap it up, Chris.
Well, thank you again for having me. I really appreciate it, Dario.
Absolutely. Thank you so much. Thank you, everybody who attended today. Everyone be safe. Have a wonderful weekend, and stay tuned for our webinar in a couple weeks. Thank you.
Stay safe.
Bye-bye.
Bye-bye.